If you look at all the cases in my career that I've won where I told my client, don't take any deal, go to trial, go all in, your hand is so good that you are not going to get convicted. And you look at the number of cases that I've done that on and the facts in the cases where I've done that, you can see that I have a speed that I can say based on my experience with the facts, the prosecutors, the judges, I have an ability to predict what is a likely outcome, to advise my client about what they should do. I mean, I've heard a lot of lawyers and judges tell people, you never know what's going to happen when you go to jury trial. And I just don't believe that. I feel like as a lawyer, I do have a pretty good idea of what's going to happen in certain cases within a range. And the reality is I was put in jail in March of 2008 on a case where I told my client, there's no way I'm going to lose this trial. He was arrested with no odor of alcohol, performed well on the field sobriety tests, and the reality is that a Travis County jury, in my opinion, would never have convicted this guy. And I had a judge telling my client there are pros and cons in going to trial. And this was a client who had been sitting in jail for so long that he had more back time credit than the maximum possible sentence he could have received under the law. Basically, he had nothing to lose by going to trial on a case that I felt like I would never lose. And so I was put in a position of having a client who said, you know what, I don't feel like messing with it. I'm just going to plead no contest to a DWI. And that was something that was very repugnant to me because not only could the state not prove it, the only reason he was willing to do it was because he wanted to get out of jail. You see, a lot of times as it happens, I represent people who when they get out of jail on bond, they go commit more offenses. I represent everything from first-timers to career criminals. And this guy was definitely not a first-timer. And so he goes back in custody on a cocaine case and accepts his 7-month sentence. And the day that he accepts his sentence, he goes into court and tells the judge, I want a jury trial. And then, for whatever reason, his case never seemed to get a day in court until after he had finished laying out his 7-month cocaine sentence. Then when he gets brought back to court, he just wants to plead guilty and get out of jail right then with a jury in the hallway. And I told him that absolutely not, that was a terrible idea for somebody with a criminal record to plead to a DWI first, because DWI is an enhanceable offense. And people do go to prison for DWI. And every person who goes to prison for multiple DWIs got a first one on their record. And that's why it was so important for me not to let him get a first conviction, especially on these kind of facts. And so I was in court fighting for a client who didn't even care about whether or not he got a conviction. And the reality is that I was put in jail, I got out of jail, and then I had to go back to jail. But my client, he never got a conviction for DWI. And you can get a pretty clear idea about what kind of lawyer you're talking to by asking them, hey, what's your opinion on Adam Raposa and his contempt case? How do you feel about Adam? How do you feel about the fact that the defense bar and the Austin Criminal Defense Lawyers Association didn't want to support him? How do you feel about that? Because you will see the lawyer who prosecuted me is now a defense lawyer. And you'll find plenty of lawyers who would say, well, Adam Raposa is just disrespectful, and Adam Raposa needed to be taught how to act. And then you'll find lawyers that say, that dude does his job. And when you have a client who's absolutely not guilty of what he's being charged with, and the lawyer says, I'd rather go to jail than put my name on a judgment of guilty, that guy's doing his job, and he's doing it like a badass. That's a lawyer you should consider hiring.